Welcome to the presentation relating to family law. This is Module 11. Today we're going to talk in general terms about pleadings that are filed in a family law matter in the state of Texas. Very general terms we'll be discussing this topic. If you've already taken family law, this material will be very familiar to you, and you will realize that there's a lot more to know about the topic, obviously, than what we're able to cover in one unit in this class. But I'll introduce you to the topic. If you haven't yet taken family law, this is kind of a good first sample about this topic. One thing I'd like to point out is that sometimes when we start looking at some topics in this area and we introduce some general topics or some general information about the topic, it's easy to assume that there isn't a lot more to know, that, oh, okay, now I know about this topic. And this is, I think, a particularly dangerous area to come into this topic with that preconceived idea. Perhaps you or a family member are in the process of going through a divorce or a child custody dispute or some other issue. While the information that you'll receive today could be helpful to you, please don't assume that I'm doing an exhaustive discussion of the issues relating to these topics. That certainly you would want to do quite a bit more legal research and talk to legal professionals to get a more complete view of this very complex topic. So let's get started. Family law. By its very nature, family law is constantly evolving. We find in our culture that there are different ideas about family, different ideas about the roles of fathers and mothers, children, grandparents, husbands and wives, different definitions of marriage. What is marriage? What is its purpose? How long and under what circumstances should a marriage continue? And so these evolving ideas sometimes result in legislative changes, sometimes they result in case law changes. And they can really get to some very basic ideas. So there are definitely ideas out there nowadays in our law, either through judge development or through legislative developments, that would have been completely not considered appropriate 50 years ago, or in some cases even 20 years ago. And very likely there will be ideas that express different values 10 or 20 years from today that maybe we would be surprised by if we were kind of transported into the future a few years. So it's very much evolving, reflecting changes in our culture, in our values, in societies, sometimes reflecting different views about the roles of different people in those communities. So it's a very interesting topic. It's obviously a very emotional topic. And it's an important topic. Almost all of us have been a member of a family or will be a member of the family in the future, and certainly legal issues can develop in that context. Family law litigation is rarely a happy thing. Rarely is litigation a happy thing anyway, but certainly when you add the family component, there's usually not too many winners in those situations. And it does require practitioners who have a special sensitivity to the concerns that people going through a family law litigation are likely to have. Most family law cases are going to require judicial action. Sometimes the judicial action is fairly neutral or even positive. For example, if I want to adopt a child, I am going to need judicial action. And obviously that's rarely going to be a sad situation. It's a happy time when a family grows. And then there can be other times in which a change is a positive for those concerned. But unfortunately, more often than not, family law litigation involves some unfortunate changes that may have happened in the family. So how does a family law litigation start? Well, there needs to be somebody typically who initiates the lawsuit. And this person is going to be called, in Texas, the petitioner. And the person who is responding to the petition filed by the petitioner is going to be the respondent. So we have the petitioner, we have the respondent. That is the title that we use for these individuals. Now, sometimes people assume incorrectly that the petitioner is the person who wants a particular action to happen. So imagine, for example, this is a divorce petition. And the assumption might be, well, the person who's filing the petition is the one who wants the divorce, and the person who is the respondent is not the person who wants the divorce. And that could be true in an individual case, but it doesn't necessarily follow that it is true. It may be that both parties want a divorce. It may be that the respondent is the one who is really seeking the divorce, but the petitioner is the one filing the divorce, perhaps because of strategic reasons, or perhaps they have agreed that that is the most appropriate way to proceed. Texas, like virtually every other state in the United States, is a no-fault divorce state. So if a couple wants to get a divorce, or even if one member of a couple wants to get a divorce, it's not possible to end or to stop or to frustrate for a very long period of time the prospects of getting that divorce. It will happen. The person who perhaps doesn't want the divorce usually is going to be directed by his or her attorney to say, hey, it's going to happen. I understand you don't want it to happen, but that's not something you can change or affect. What you can perhaps change or affect is how the divorce proceeds and what are some decisions relating to the assets of the marriage and perhaps to the children of the marriage. So there are some things that a reluctant divorcing person might be able to affect, but he or she is unlikely to be able to stop the divorce or even slow it down dramatically going forward. So keep in mind that when we call someone the petitioner, we're not saying this is the person who wants a divorce. Maybe the person who wants a divorce, maybe not. This is simply the person who filed the paperwork. And the respondent's the one who's responding to that paperwork. The petitioner is like the plaintiff in a case, and the respondent is like the defendant. But of course, in a traditional civil lawsuit, the plaintiff is obviously the one who wants to file the lawsuit, and the defendant is definitely the one who is defending his claim against whatever the thing that the plaintiff is advancing. So that is a different dynamic here. The petitioner is not necessarily the person seeking whatever the action might be. Pleadings in family court oftentimes look fairly similar to pleadings in a general litigation case or civil litigation case. For example, the main document is a petition, and of course that's the term that we use in Texas for in state court for the document that starts the lawsuit. But sometimes it's going to be styled differently. And when I use the term style, I mean the style of the case, the caption of the case is going to look different. We're going to look at a few examples here. I'm going to flip to the next slide, which shows you an example of see if I can make this a little bit bigger. Oh, here we go. Okay. So you can see up here on top, you're going to petition. When you're drafting the petition, you obviously don't know what the case number is going to be. That's something that the clerk of the court is going to provide for you. So when you submit your document, and this is probably going to be filed electronically, so whether you submit it electronically or you're able to file it in a paper form, you're going to leave this blank, and the clerk is going to stamp right here the number of the case. Going forward, all the subsequent documents filed in the case you're going to type in that number that the clerk has stamped on the document. So it's only left blank for this first document. Then you have these little section signs. We've seen these before in civil matters, and it's the same way. Well, I'll go over how to make them again, but it's the same process that we've used in previous cases. Then over here we say it's in the district court. Now we have lots of different state courts in Texas. The default court is going to be the district court. A district court handles cases of general jurisdiction in a particular district. And most of the time the district has the same geographical bounds as a county. There are some less populated counties that might, two counties might share a district. But usually it's going to be one county. And so in this particular case, this is a district court in Bell County. And because most districts have more than one judicial district court in that particular county, you need to leave this space blank so that that can be added. So it's given a case number by the clerk and it's assigned to a particular court. This might be the 117th judicial court, or the 192nd Judicial Court or the 83rd Judicial Court, whatever. So it's blank here because you don't know what the answer is going to be, but in any subsequent document, then this number will be added. And that number tells you which courtroom the case is going to be heard in. It tells you which judge. Now, of course, there can be an election and the judge might change, and obviously if the judge is no longer in that court, then the new judge will be the one that handles it. But you'll be able to figure out based upon who currently is the judge of that court, who it's initially assigned to. Then let's look over here. We see that this doesn't look like our standard caption for a civil case, because in a civil case you usually have, you know, this name, comma, plaintiff, comma, versus this name, comma, defendant, period. We don't have that situation at all. We have in the matter of the marriage of. So we have this is a new thing. We don't have this in a traditional civil case. And then we don't have a versus, we just have and. Many times this and would not be capitalized, and I don't think it's really necessary that all the words in this be capitalized either. And it's possible that someone might say Jane Doe, comma, petitioner, comma, and John Doe, comma, respondent, period. You could have that, but it's not really necessary either. It's obvious in this context that Jane Doe is going to be our petitioner. Her name appears first, just like a plaintiff's name would appear first in another document. And similarly, John Doe is our respondent. He might be the one seeking the divorce. He might be the one not wanting the divorce, and vice versa for Jane. We're not getting any information about who wants the divorce in this situation. Okay, so this is the style of the case. Now, if Jane and John's marriage has resulted in children, meaning that a child has been born during the time of their marriage to Jane, or Jane and John have adopted a child, or perhaps John already had a child and Jane adopted John's child, or Jane already had a child and John adopted Jane's child. Those children would be children of the marriage. But let's say that Jane already had a child before she married John, and the child is not biologically John's. Well, that child is not a child of the marriage unless and until John adopts that child. So even though this child may have been born the day before Jane and John got married, and the child is 17 years old and has lived virtually his whole life in the household with Jane and John, from the legal standpoint, John is not the father of the child, and so therefore that child would not be a child of the marriage. Same thing would work if John had a child from a relationship other than his relationship with Jane. Even if the child was born while he was married to Jane, if it's not a child who is biologically Jane's, then that child is not a child of the marriage. But in the event of a child born of the marriage, either biologically or by adoption, then you would list those children right here. I'll show you an example of that later on. So they would be listed on the petition as well. I'm going to clear this up so it's a little bit less messy since I've made so many marks. Here we go back to a blank one. Now we're ready for the next phase of this, and that's going to be the name of the document, Original Petition for Divorce. You say original because it very possibly could be the case that it's going to be amended later on, and then you would change the name to Amended Petition for Divorce. And then pretty much this stuff is pretty boilerplate. You have the discovery level. This is a very common thing to appear in a Texas state court. It explains the level. This one is a level 1 discovery case. The case that we'll be doing in the assignment for this module will be a level 2 discovery. So you'll have this information. So obviously if your model said level 1, you would make sure that you change this 1 to a 2 for this particular document. You may think, well, what is level 1? What does level 2 mean? That's beyond the scope of this class. When you take LGLA 1344, which is the Texas Civil Procedure course, you'll learn more about what the rules of discovery or the levels of discovery mean in a particular litigation. It says there are no children involved in this divorce case, and the value of the marital property is more than 0 but less than $50,000. And you can probably surmise that that's what level 1 is about. In a divorce, these are the characteristics that qualify it as a level 1. So this is kind of repeating that information. So obviously if you're a level 2, you're not going to include these facts because one or both of these facts can't be true if you're a level 2 discovery. Then we have the parties. This suit is brought by Jane Doe petitioner and respondent is John Doe. So you can see the order. If John Doe were the petitioner, then John Doe's name would be up here and Jane Doe's name would be down here. The domicile, petitioner, of course this is Jane Doe, so whenever you see petitioner now, think Jane Doe. Whenever you see respondent, think John Doe. Let me pause here for a second and talk about the use of the term petitioner or plaintiff or defendant or respondent. This is really a matter of personal taste of the attorney. Some attorneys like to use the real name of the individuals, and so in that case we would see that it would be Jane Doe or Ms. Doe or Doe. Obviously, since they have the same last name, you probably wouldn't refer to them as Doe. You probably say Mr. Doe or Mrs. Doe. Some people prefer that. Some people prefer to use the title, the role that person has in litigation. So in that case, you wouldn't refer to Jane Doe as Jane Doe. You'd refer to her as petitioner. You have to define her at first so it would be clear for the reader who this person is. Some legal professionals like to mix it up, and they might refer to the person occasionally as petitioner, sometimes as Jane Doe. I would say the more preferred style nowadays is to not dwell on the title that the person has in litigation, but instead to refer to them by their names. It's a little bit less confusing for the reader, and one of the goals in modern legal writing is to make it as easy for the reader to follow the story as possible. It's also a way to kind of humanize the people involved in the story. Now, sometimes what legal professionals will do is they will refer to their client by the humanized name. So let's say we're representing Jane Doe, we'd refer to her as Miss Doe or Jane Doe, and we'd refer to the soon-to-be ex-husband not as John Doe or Mr. Doe, but as respondent. That's a way to kind of depersonalize him. You'll see that happens, and if your attorney chooses to do it, then you ought to follow his or her lead. But I think that's not a best practice. It's fairly obvious what you're doing. It's a pretty clear kind of manipulation. So it's usually a better practice if you're going to refer to your client by his or her name to refer to the other side by his or her name. If you're going to use petitioner for one, you ought to use respondent for the other. But again, if your attorney says that's not what we want to do, then you're going to follow the advice of the attorney. The domicile. This establishes that this particular court has jurisdiction in this matter. And you can see we're really getting at two things here. Is it appropriate that this divorce be filed in Texas? Well, with a basis. Well, petitioner has been a domiciliary, I guess, of Texas for the preceding 6-month period, which is a requirement. And she has to be a resident of this county for the last 90 days. So this establishes Texas is the appropriate court and Bell County is the appropriate county. That's what we're getting at. So it's a jurisdictional claim. And then we have a choice here. Service. No service is necessary this time, or process should be served on respondent at. Now, obviously, you wouldn't include both of these in here. You'd either have no service is necessary at this time, or service should be at this location. So whichever one is the case is the way you obviously proceed. You wouldn't have or, because then we don't know, is this person going to be served or not? And there needs to be a statement about the protective order status. If there is a protective order in this case, then the court needs to know about that because obviously there's concerns about the safety of individuals. If there's no protective order, that's also information that needs to be known by the court. So that's why this information is provided. It is required. And then, of course, they're going to go into a lot more details about the marriage, and I'm not going to go into this. But this just introduces you to some basic stuff about this particular case. Now, when John Doe responds to this, he'll, of course, have the case number, and he'll have the judicial court. But the rest of the style of the case will be the same. And he will say, he won't obviously say original petition for divorce, but he'll say original answer to the petition for divorce, for example, and proceed from that standpoint. Here we go. Okay, let's look at SAPSR. Unfortunately, many times a divorce not only affects the husband and wife, but also minor children. When there are minor children of the marriage, either biological children or adopted children, they have to be included in the divorce petition. And this type of case is called a SAPSR case, and you can see where SAPSR comes from. It's a suit affecting the parent-child relationship. This is a term that is used, as far as I know, in all 50 states. So it's not something that's unique to Texas. Much of this has been standard. Certain aspects of family law has been standardized across the state, so that divorcing couples or couples involved in child custody situations won't forum shop. Imagine that I would like custody of my child, and I think that the courts in New Jersey are going to be especially inclined to award me custody. Well, I might be inclined then to go to New Jersey with the child and file for custody there. But maybe my former partner thinks that the courts in Wyoming would be especially inclined to his perspective in the case, and so he's trying to move the child to Wyoming. You can see kind of the chaos and upheaval that can happen in that situation, and so to some extent there's some standardization of how these cases are approached that allows there to be more predictability and less forum shopping. So what do the family courts do in this kind of, if they have a SAPSR case, what are they going to do? Well, they might be asked to do several things. They might be asked to determine the parentage of a child. Perhaps there's a dispute about who the father of the child is, who the biological father is. The courts might be asked to consider custody. Who will have custody? Will they have a joint custody situation, or will they have differing levels of custody? And who will be able to make decisions about the primary residence of the child? Child custody issues can be very complex with lots of different factors in it. Child custody also plays a role in the child support perspective, how much support one or the other parent will be required to pay, and who's going to receive that and who's not. Those are common issues in SAPSR cases. Some cases can have all three issues in it, and some cases might only have one of these issues in it. Sometimes people think, well, my partner and I never got married. We've had a child. Yes, I can say I'm the woman. I concede that he is the biological father, but there's no need for a SAPSR suit. I'll just say it's my child. I gave birth to the child, so therefore he doesn't have any right to the child unless I give him rights to the child. That's not how it works. If he's a biological biological parent of the child, then from a legal standpoint, he has right to have a relationship with that child, and he can apply for custody of the child, and he can apply to have a determination that he is the legal parent of the child. So while probably the most common SAPSR case relates to a divorce situation, you can definitely have SAPSR cases where the couple has never been married, but their relationship has ended and there are children to be considered at that point. I'm going to bring this back to the page here. Parents of minor children seeking divorce must include a SAPSR with their divorce petition. So let's imagine that Jane and John Doe have 3 children, biological children from their marriage. And one is Amy, and Amy is 20. Then there's Tim, and Tim is 18. And then there's Sue, and Sue is 16. Well, the only child that would be subject to a SAPSR is Sue, the 16-year-old. Amy and Tim are over the age of 18, and so therefore there would not be any suit affecting the parent-child relationship because Tim and Amy, while they're still children of their parents, they are no longer children because they have reached adulthood. Let's imagine, though, that the family only had 2 children. Sorry, Sue. Bye-bye. We're going to have only Amy and Tim as the children. Well, since they're both over the age of 18, in this case, even though there are obviously children in the marriage, there would be no need to have a SAPSR case because there are no minor children. And so for only the children that are children of both parties, by either blood or by adoption, are included in the SAPSR suit. But if the parents had adopted the children either together or maybe one, Amy might be the biological child of John, and Jane has adopted Amy. And once a child is adopted, then from a legal standpoint, the adoption relationship is treated very much the same, virtually the same as if it was a biological relationship. So those are what we mean a child of the marriage. But let's say there was a third child. Actually, let's get rid of Amy and Tim, and we'll go back. We'll say, clear this off. Let's say that John and Jane Doe have they have Ted, who is 10, and then Jane has Sally, who is 15. And Sally is from a previous marriage. But Jane's previous husband died, and so Sally does not have a legal father. Sally is under the age of 18, but John, who is the father of Ted and is the husband of Jane, has never adopted Sally. Even though Sally has grown up with John in the role of a father, there is not that legal relationship. So when a SAPSR suit is filed, it would just include Ted. John would not have any rights to, he is not the parent of Sally from a legal perspective, so there would be no need to have a SAPSR suit because John would have no legal responsibility to pay child support, would have no right to have custody of Sally, and there's no parentage to determine because no one is saying that John is the parent of Sally. So it's important to keep that in mind. Sometimes the relationships that people have are more complex than the law might acknowledge. Well, it's kind of a black and white in this area. Form pleading is very, very common in family law. Although families are infinitely different with all kinds of special and complex aspects to them, family law is pretty cut and dry. You get a divorce, you fill out the form, and even though the reasons for the divorce are going to be so subtle and complex that you couldn't even reduce it to a document, what you do is you actually just check off the boxes, and there's just a few reasons why you get a divorce, and you just list them. So really, you're not, when you're doing pleadings in a family law case, you're not really intending to make an emotional plea to anyone. You're not intending to tell the story. You're not intending to show, oh, my client was the virtuous one, and her husband did horrible things, and he cheated, and he lied, and he stole, and he did all these terrible things. That's not the place for it in the form pleadings. In fact, the pleadings themselves are going to be very boring, very dry, almost no details whatsoever. That's the way they ought to be. If you decide to get creative and start telling the whole lurid details of what John or Jane actually did in the marriage, very likely the judge will instruct or will have that part of it struck, because that's really not perceived of as the appropriate role to include that in the pleadings. That evidence may likely come out during the trial if it gets to that stage, and that's appropriate, but not in the pleadings. If you're looking for good sources for these types of form pleadings, you can go to the Coons' book, Texas Family Law Handbook, as well as the Dorsanios book. Dorsanios is available in the Spring Creek Library. They're kind of a powder blue or baby blue color, and there's lots of volumes. There's probably 20 volumes in the stacks, and there's a section on family law form pleadings, and you can get those documents from there. There's other form books as well, but those are two good ones. For the purposes of this assignment, I don't think you'll need to look at either one of those places, but they can be good sources in future as you might have reason to need those. Even though you don't want to go into a lot of innovative language or provide too much information, you obviously will have to edit the pleadings that you get from a form book to reflect the specific facts of your client's case. For example, if your client is getting a divorce because of the adultery of his or her spouse, you'll have to say adultery in there, or something that's the equivalent word for that. You won't want to omit that fact. You might have to add that. You're not going to describe in detail when the adultery happened, who the adultery was with, all the shocking facts about the adultery. No, you're just going to say, adultery is the grounds for the divorce or something along those lines. So you don't want to provide unnecessary facts, but you do want to provide facts that present your specific theory for recovery in a case. You don't want to leave any blanks in a form. Now, of course, if you're filing the petition, you'll want to leave the case number blank, the court number blank, and there may be a place where a date is added, maybe the date of the signature or something like that. But other than that, you'll want to make sure that it is complete before you submit something to the court. And you won't want to have any ors unless it makes sense in the context. It's a good practice in all litigation matters to visit the court's website to look to see what the local rules are for that particular court. It's also a good idea to look to see how, to go to the clerk's office and to see other documents. If you're wanting to file a divorce petition, you might want to look at a few divorce petitions that have been filed in that court. The local rules may not provide you a lot of specifics, but you might discover that there are some quirks that happen in this particular county that you couldn't have anticipated. For the most part, when you are filing documents in a court, you want your documents to look just like the ordinary everyday documents filed all the time. You don't want the format of the documents to stand out. If everybody files documents in Times New Roman, you don't want to file yours in Helvetica. If everybody has, an 1.5 inch margin on either side, you don't want yours to be 1 inch, because that signals to the other people, the opposing counsel and the judge, that you're a newbie here, that you don't kind of know how things are done. It doesn't impress, and you may find yourself being hometowned, being taken advantage of in certain respects. It kind of shows it tips your hand that you're in a weaker spot than the other side. Now, of course, the actual content of your documents, you might want to be careful and somewhat innovative, although let's just say in the area of family law, you don't want to be very innovative, but you can think about, within the constraints of not providing facts, more effective ways of presenting certain types of information. You'll want to look up, the names and address of the court clerks. You can find that through an internet search, of course, or you can just call them up and find that information out. If you have any questions about family law documents, especially divorce petitions with SAPSR pleadings in it, feel free to send me an email. If it's a question I think that will be of general interest to the class, I'll probably post my response without revealing your name to the class. If I think it's just an issue that maybe something I can help you directly with, then I'll communicate directly with you. Alternatively, if you have kind of a bigger question, one that can't be answered in a couple of sentences, come to my office hours. I'm happy to work with you on formatting your documents, making sure that they look effective and that you're going to put your best foot forward. Sometimes it just takes a few minutes discussing the documents, and it can really help you get focused on how to make your documents look good. At this point, I'm going to share my desktop, and we're going to go through some documents that you will find in Learning Module 11. To family law. I'm going to go into that. This first item that we have here is the PowerPoint that we just covered. Here are some excerpts. I've already clicked on it here. Here's some excerpts from the family code. There's just 4 pages here, and this is the actual statutes. The neat thing about this statute is that it's quite easy to understand and read. Family law in Texas, as it is in most states, is very code-driven. Yes, there are cases, but most of the litigation happens and is resolved by looking at the statute itself. And you can see here it talks about every marriage is presumed valid. It talks about the grounds for divorce. We have insupportability. This one right here is the traditional one that people think of as no-fault divorce. We don't have something called no-fault divorce, but this is essentially the same thing. On the petition of either party to a marriage, the court may grant a divorce without regard to fault if the marriage has become insupportable because of discord or conflict of personalities that destroys the legitimate ends of the marital relationship and prevents any reasonable expectation of conciliation. Now, when you hear this, you might think, well, gee whiz, that doesn't sound like no-fault divorce. It sounds like, or at least it doesn't sound like one party can force the other party to get a divorce, because after all, the court is the one that's going to decide whether the marriage has become insupportable. Well, that's technically true, but if one party of the marriage says, I'm out of here, I don't want to be married, then the court is going to say, okay, well, it's become insupportable because by definition, if one person is unwilling to continue the marriage can't continue, at least not in the meaning that we currently have for what a marriage is. So one party can essentially say, I don't want to be in this marriage, and there's nothing you can say that's going to persuade me, and the court is, under those circumstances, going to have to go ahead with the divorce petition. But there are other grounds for divorce, and certainly when you're filing a divorce petition, it's pretty common to present more than one reason. This first one, insupportability, is almost always going to be listed because if there's no evidence to support the others, or somehow or another it's concluded the others are not valid, you can always get a divorce on this basis. So this is a guaranteed basis for divorce. But sometimes it's strategically smart to have other bases for it. Cruelty, adultery, conviction of a felony, abandonment, living apart, confinement in a mental hospital. You can see the defenses to a suit for divorce for recrimination and adultery are abolished. Condemnation is a defense to a suit for divorce only if the court finds that there is a reasonable expectation of reconciliation. And talks about the residency rule for a divorce, and we see here that you have to live in the state of Texas for 6 months, the person filing the petition, and you have to live in that particular county that you're filing in for the last 90 days. And then this talks about the requirement that when there are children born or adopted to the marriage who are under 18, they have to be included in the divorce petition. So this kind of gives you an overview. There's several other topics that are kind of beyond the scope of this course, but I wanted to introduce you to these. Then we have some sample documents. I've identified 2 that I want to draw your attention to, but let me just open up the sample documents generally so you'll be able to see. I'll go down here, and the 2 that are most relevant are going to be your original petition for divorce with kids, which of course is the SAPSER, and the sample petition for divorce with standing orders. So let's look at those. Here is one. This is that second one. This is sample petition for divorce with standing orders. You can see this looks similar to the one that we had in Bell County. First thing that we have is we have a place, right here for putting the case number, because this is again a petition. We don't know the case numbers yet, so it's blank here. We don't know what the judicial court is going to be filed in Travis County, which obviously is going to have lots of different courts, so we can't predict where that is going to be. And we see the same title here, in the matter of the marriage of. This time they actually did say petitioner. You certainly could put a comma after this R right here, and you could put a period after the T. You could certainly not have made everything capital. You could have indented this if you wanted, and indented this if you wanted. Again, I wouldn't worry too much about that. Probably, again, what I would do if I were not routinely practicing family law in Travis County is probably look at a couple of divorce petitions and see kind of how they commonly look. They may be all over the map. Some of them might indent petitioners, some might not. Some might capitalize everything, some might not. And so you can get a flavor for how these divorces ordinarily look. This one has original petition for divorce all in caps, pretty common way to call this. Probably the average one might have been in bold. I'm a little surprised that we have all this in bold and that's not in bold, but you know, whatever, not a big deal. Then we have the discovery level. You can see this is again a level 1. And why is it a level 1? No children are involved, and if we had children involved, we would have talked about them below the husband and wife's names. And the value of the marital estate is less than $50,000. Let me pause on this one. When we say the marital estate, what we're talking about is the community property. It is possible that Jane Doe is a multimillionaire, and also her husband could be a multimillionaire. But the actual community property, the stuff that they own together, is less than $50,000. Most of the time when one or the other party is significantly wealthy, the estate is going to be over this $50,000 hurdle, but it doesn't necessarily follow. Perhaps this was a marriage that only lasted a week. Well, there wasn't a lot of time to accumulate community property under those circumstances. Here we have the parties. This suit is brought by John Doe petitioner. We already knew that because his name appeared first, and we had the word petitioner, so no big news there, flash there. his driver's license number is, and we're given that, and his social security number is this. And usually we're not going to show these because these are public documents, and obviously a person doesn't want that kind of confidential information available because of identity theft reasons. If John Doe happened to have known Jane Doe's driver's license number or social security number, that could have been added as well. The domicile, well, we can see that respondent, and of course here, who's respondent? Jane Doe. So you can see they're using the petitioner respondent title. They're not saying John Doe or Jane Doe, but we have respondent, when we mean Jane Doe, has been a resident of Texas for 6 months, and she's a resident of this county for 90 days. So there's the grounds for filing in Travis County. Service. If petitioner is unable to obtain a waiver of service, process should be served on respondent, Jane Doe, at this particular address, or such other places may be found. If respondent cannot be personally served, then she should be served by substitute service as authorized by the Texas Rules of Civil Procedure or the applicable statutes. Let me pause for a second. It's beyond the scope of this course to talk about service, really, but I want to flag up for a second. Typically in a divorce situation, service is not accomplished through a formal process server. It costs money to do that. In most divorce situations, there's not a lot of extra money, and even if there is, it seems like a silly way to spend the money. So typically, the person who is being served with the papers or wants to be served with the papers is going to waive service because it's kind of an unnecessary expense that's really just going to shrink the assets that can be divided. But sometimes the emotions are so raw and so sensitive that the person is unwilling to agree to that, and under those circumstances, you do have to go ahead and serve. You can see here we have our footer here, original petition for divorce. You can see how that matches the name up here. We've talked before how it's a best practice to have a footer that matches the name of the document that we have, and you can see they've also included the page number. Protective order statement, we already talked about this. There's no protective order in this case. You have to reveal it if there is. Then we have the dates of the marriage. And you can see it's obviously there hasn't been a divorce yet. That's what this document is pursuing. So they're still married, but you usually will list the date that they cease to live together as husband and wife, meaning that they have moved out. They could possibly still be living in the same house, but they are having different bedrooms, for example. The grounds for divorce, and you can see it's insupportability in this case. And you can see the language here tracks very closely the language in the statute. Let's just read this, then we'll compare it to the language in the statute. The marriage has become insupportable because of discord or conflict of personalities between petitioner and respondent that destroys the legitimate ends of the marriage relationship and prevents any reasonable expectation of reconciliation. Let's look at this. The marriage has become insupportable because of discord or conflict of personalities that destroys the legitimate ends of the marital relationship and prevents any reasonable expectation of reconciliation. So you can see basically what the paralegal or attorney did in this case is just basically cut from the statute and put it in there. Now you might be thinking, well, how uncreative. Boy, that wasn't a very good job. Well, it's exactly what you want in a divorce petition. You don't want to say, Bob has a hot temper and he's always yelling and he's so unreasonable, and no, that's not the purpose of this. You just say the standard boilerplate language. There's no need to go into the specifics. And in fact, that's not a best practice at all. There are no children. And again, this language is standard, and you do want to go on and say none are expected. Now, it might be that Jane is 90 years old. Well, of course, none are expected. But it's assumed that you want to state that is, basically what you're saying here is Jane is not pregnant with a child at this point in time. Then there's a discussion about community property. Petitioner requests the court to approve the division agreement of the party, if any, and if such an agreement is not made, petitioner requests the court to divide their estate in a manner the court deems right and just as provided by law and to confirm to the respective parties their separate property. It's pretty standard language to put into a divorce petition. Standing order, and in some counties you have to attach the standing order, and this one you do, Travis County, and so you'll see that it's attached later on. Change of name, respondent request a change of name from Jane to Jane Maiden. Her maiden name is in fact Maiden, which was a previously used name. You pause and you may be thinking to yourself, wait a second, well, why is John Doe the petitioner telling the court what Jane Doe, the respondent, wants. That's kind of weird. It is weird. But obviously this is a planned document. It may be that Jane Doe is the person who really wants the divorce. But they have agreed that John Doe is the one that's going to file it or whatever. But you can see that Jane Doe is not surprised with this. John Doe and Jane Doe have discussed it, and in fact Jane has communicated her preference to change her name. Now obviously John might be making this up. Maybe Jane wants to say Jane Doe, or maybe she wants to revert to another surname that she's had. So he might be lying through his teeth, but probably not. And then finally we have a prayer. When you see the term prayer in a legal document or in a pleading, it doesn't have a religious connotation. It goes back to the maybe the more old-fashioned way that this word was once used. It certainly has a religious connotation, but it can also mean beg. I pray you do something. It doesn't necessarily mean that when you say that to somebody that you're saying, I think you're God, you're saying you have some authority and you can use that authority, and I'm humbly asking you to do that. And so when this is directed toward the court, that's what we mean by prayer. No, but John Doe is not thinking to himself, the judge in this courtroom is God. He's thinking, I am being polite and I am deferring to the power of the judge. And this is a very, very common expression. So it's not anything controversial or offensive or sacrilegious. Prayer is petitioner. Again, that's John Doe. Prays that citation and notice issue as required by law, and that the court grant a divorce and all other relief requested in this petition. Petitioner prays for general relief, respectfully submitted. And you can see John Doe is doing this on a pro se basis. And he actually lives in Dallas, so you can see he's relying upon Jane Doe's residence for this purpose. And again, we see the standing orders local here. Again, this is anything that John Doe would draft. This is stuff that was prepared by the Travis County judges, and you'll see at the end it's signed by all the Travis County judges at that particular time. Okay, so that gives you an overview about that particular petition. We have another one. Wanted to go over this one as well. Same situation here where we have the cause number. You're going to leave that blank so it can be added by the court. Have this in so that gets lined up. A little bit of a refresher. How do we do that section sign? We go to insert, we go to symbol. If we've used the section sign recently, we'll see it right here. We can click on it and it appears. If we haven't used it recently, we can click to more symbols and hunt around for it. And so here we go. I'm going to hunt. It's right here. I click on it and I insert it, and I close, and it's right there. Obviously, I only need one section symbol there, but it's showing you how it looks. And again, we say in the district court, we leave the actual number blank on the petition only. Subsequent documents are going to, you can actually put district court, whatever. And if you, again, when you file the next document, you'll actually put the case number, whatever the case number might be. We don't know it now, so we're just going to do the blanks. And this is the cause number is typically going to be centered on the top of the document. Okay, so we have in the matter of the marriage of, and then you're going to put the name of the person. We'll say that it is Jeremy Green. Probably a comma there. You might well put his name all in caps. Let's go ahead and do that. Jeremy Green. I'm going to reduce and to A and T. And then we're going to say that Jeremy is married to Sarah Smith. So she retained her maiden name. Obviously, if she chose to retain her married name, you wouldn't say she's not Sarah Green legally. In the interest of, and this is for the children. Again, this is not all the children that Sarah has ever had or that Jeremy has ever had. It's only the minor children, it's only the children that are both Jeremys and Sarah's. So we're going to say, Amy Green is one minor child, and we'll say Timothy Green is the other minor child. There might just be one, so then it would be in the interest of Amy Green. And of course, this reflects the county in which the course filed in. We have original petition for divorce. We have the discovery level, and you can see it's set up a little bit differently here than we have the other one. Let me just flip over to the other one so you can see a little refresher. They have little italics here. They don't have it centered. I would say this is probably the more common look. And again, this would be an example. You're following Collin County. Maybe this is the way the documents look. You'd like your document to look like this if this is the kind of document your judge sees every day. If in Travis County their documents look like this, you probably want your document to look like that. It's not wrong if it doesn't, unless the local rules say that it's wrong. But it's better to see that your specifics match. And you can see in this case it's a level 2. And you can see it's a level 2 because, of course, there is a child-criminal relationship. And you could provide the actual reasons by looking up Rule 190 of the Texas Rules of Civil Procedure, but it's not necessary. Then you have the parties. Well, we know who the parties are. We know it's Jeremy Green. That's what I could type. Okay. This is justified, fully justified. I prefer my documents to only be right justified. It's not wrong, and attorneys have differing views on it. Sometimes there's local rules on it, but that's just my preference. So I'm going to make mine left justified, not fully justified. So, Sarah Smith, is that what I knew? Sarah Smith is a respondent. The last 3 digits of respondent's Texas driver's license number are, okay, and I'm going to say it's 1, 2, 3. Domicile petitioner, that's Jeremy, and I would, you could say, Mr. Green has been a domiciliary of this state for the preceding 6-month period, and this county for the preceding 90 days. No service is necessary at the time as a waiver or citation is expected. There is no protective order, the date of the marriage. The parties were married on or about this date. You can just say on. You can say on or about. I mean, obviously, a person knows when they were married. And ceased to live, there should be a comma actually right here after the date. And ceased to live together as husband and wife. That might be a little bit vaguer. You might not be sure of the exact date, for example. Maybe he moved out, but they talked about getting back together. Who knows, whatever. You'd add the fault grounds, and here's the no fault grounds. Of course, you'd remove the stuff in brackets here, and you might add the fault grounds. Let's say that Jeremy is seeking divorce because of cruelty. Okay, so I'm going to copy this, and I'm going to plop this down here to clean up the font and all that good stuff. Just kind of getting it started here. See what font do we have here? We had Paliento, Palatino. So I forgot to do that. Sorry about that. Drop it to 12. Okay. And we need to have, missing this double spaced here. So let me go back to the code. Okay, so early, here we go. Respondent Sarah Smith tab is guilty of cruel treatment toward Jeremy Green, the complaining spouse, of a nature that renders further living together insupportable. So that would be a way of getting the grounds of divorce. But you always want to include the insupportability one, because if you can't, so let's say Jeremy wants a divorce. Maybe he'd like to have it for cruelty, but if he can't get that, he still wants a divorce. And then you would provide information. In this case, we have Amy. You would indicate her sex, female, her date of birth, and where she lives currently in the county. And similarly for any other children. And you'll have this statement if this is a true statement. There are no court-ordered conservatorships, court-ordered guardianships, or other court-ordered relationships affecting the children of the suit. Obviously, if that's not true, you're not going to say that. And again, this is a pretty standard thing. We think we're going to be able to work out child support and all this good stuff, but if we can't, we're going to ask that the court do that. And there's a division about community property, and again, it says we think we're going to be able to work that out. Again, this is pretty boilerplate, but if we can't, we're going to ask the court to do that. So this, again, pretty uncontroversial. And then we conclude with that prayer that we talked about before, and then it's going to be signed. You're going to put the name of your law firm here, and who's going to sign the document, all that good stuff. So this kind of walks you through. So because of the nature of this assignment, you're probably going to be using this sample document as your foundation one. Let's go to the actual specifics of our petition that we're supposed to file. So the assignment is your attorney, Robert Ibrahim, has assigned you to draft a divorce petition for your client, Susan Harris. Use the divorce petition document from the sample documents folder. So focus on this one, the one, I should actually say Jeremy Green, but the one that has the SAPSER part as well, okay? And so let's go back to this. You've already interviewed Ms. Harris and reviewed the file. Here's some of the facts that you've learned. There's a lot of facts here. Many of these facts you are not going to be including in your divorce petition. They're red herrings. So just because something is talked about in here doesn't mean it should find its way into the divorce petition. Keep in mind, one of the most important things about your drafting your divorce petition is leaving out the stuff that is either inappropriate or not helpful to the court. So you can look at it pretty quickly and see, I'll give an example. At one point, you find out that Susan had an affair with her current husband when she was married to her former husband. Well, how is that possibly going to be relevant to the divorce petition? You hear about lots of different children, some of whom are a result of this marriage, some of whom are not. Again, you'll want to sort through, well, who needs to be in the SAPSER suit and who should not be in the SAPSER suit. So this just kind of gives you an overview. So don't assume because it's here that it has to find a place into your divorce petition. Your divorce petition really shouldn't be much longer than this one. This one is a total of 4 pages. Yours might be 5 pages, but if you start finding that you're significantly longer than this, it probably means you're adding some stuff that is not a best practice to do so. So that concludes the presentation about family law for Module 11. Hope this has been helpful to you. Again, if you have questions, concerns, or you want to talk about some of these points in more detail, feel free to come to my office hours or give me a call during my office hours. Thank you for your attention. Have a good evening.